right. See, everyone has been admitted. All right, we are at 11:15, and so I think we will get started. Good morning. Let's make sure everyone is in the correct session. This is a panel discussion on the Clarke decision regarding the loss of warrantless arrest in misdemeanor domestic violence cases here in Idaho. So if that's not where you were meant to be, I'll wave goodbye to you as you scurry on to the other link that you need to be in. If you are meant to be here, my name is Dr. Lisa Grow at Bostaph. I'm a professor of criminal justice at Boise State University. I've spent the past 30 years working in and with criminal justice agencies, both as a practitioner and researcher, with the last 17 years here in Idaho. Much of my work focuses on domestic and sexual violence, criminal justice policy, and the use of discretion by policing professionals. But as my 16-year-old reminds me, my real job is being the mother of a teenager. I'll be serving as your moderator today, so I can spare you an academic lecture. Let me introduce our panelists for today's discussion. I've been fortunate enough to have met and in many cases worked with each of our panelists today. First is Kimberly Deugan, who came to victim services as a survivor wanting to make a difference in the lives of others. She served the last 11 years as first a volunteer, then a housing coordinator, and currently as executive director of Advocates Against Family Violence. In addition to that demanding job, she also serves on various community boards and in other service organizations that are obviously drawn to her passion for this work. Jeff Lavey recently retired after a 35-year career in policing in both Washington and Idaho, serving his last 14 years as the chief of police for the city of Meridian. But retirement didn't last very long, as he currently serves as the executive director of the Idaho Sheriff's Association. Jeff has a Bachelor of Arts degree in management and organizational leadership and is also a graduate of the National FBI Academy. The Honorable Clarke Peterson is a district court judge in District 1, where he presides over the Kootenai County Domestic Violence Mentor Court, as well as child protection and juvenile cases. Judge Peterson graduated from Loyola Law School in Los Angeles, where he also served as editor of the Loyola Law Review. That's a mouthful. He previously served as a prosecutor in both California and Nevada, and here in Idaho. He served in private practice before being appointed to the bench. Judge Peterson has been recognized by the Idaho Association of Criminal Defense Lawyers for judicial excellence. As a prelude to our discussion, I want to give a brief overview of Clarke. In June 2019, the Idaho Supreme Court issued their decision in State v. Clarke, ruling that warrantless arrests for misdemeanor crimes were unconstitutional and sending shockwaves in criminal justice and victim service agencies throughout Idaho. While the Clarke decision applies to all misdemeanor crimes in Idaho, it was seen as critically affecting policing response to domestic violence cases, of which more than 70% fall in the misdemeanor range, eliminating one of the few identified best practices and upending 30 years of practice. In its wake, our research team from Boise State conducted a series of focus group interviews with policing and victim service professionals across Idaho, which fortunately ended literally the day before the first diagnosed COVID case in Idaho. 3 infographics detailing the decision itself, the study, and our findings and our recommendations are included in your handouts. Now, 11 months after the study's results and recommendations and 2 years after the Clarke decision, we thought it important to hear from criminal justice and victim service professionals about how they are faring with this sea change in domestic violence response. So for our panelists, I will offer our first question, which is for each of you briefly, please talk about what the initial impact of the Clarke decision was on your respective agency or components of the criminal justice and victim services system and domestic violence response. And I'll open it to whoever wants to go first.
I'll go first. I think initially as advocates, because we're not on scene during the call outs and with the restricted abilities of law enforcement, it caused us to see a lot of changes in in dealing with the survivor and our responses, and we had to learn how to adapt to those. They were left with extreme confusion as to why they were left in their situation. And then we saw a much higher call volume from survivors in where there was no arrest and they were seeking their safety. More survivors were looking for shelter. And then as well as more seeking assistance with obtaining a court order to keep the offender at bay. And then more survivors and their families, the family members even as well, were calling in onto our 24-hour hotline, seeking understanding as to why law enforcement didn't care and was doing nothing. That was how this whole thing was perceived by the survivor, which was unfortunate, but this really impacted how we as advocates work with the survivors, and they were more likely to be distrustful of our advocates and the systems that we work with and that we're helping them engage with. And so it caused a lot of confusion, and so we had to figure out how to help them understand a little bit better.
I don't mind going next, Dr. Bostaph.
Sure.
Well, I'm not going to sugarcoat it. In my view, and in my area of Idaho, North Idaho, the response to the impact has been inadequate, and I would say entirely inappropriate and insufficient. Prior to Clarke, 90% or more of cases were initiated by arrest, which gave the victim a brief period of safety. It removed the defendant from the situation. All the studies say that first period is one of the most dangerous periods for the victim. It let the court put into place within 48 hours timely no contact orders. It helped interface survivors with community and system-based advocates. It sent an appropriate message that domestic violence matters. And as Ms. Deugan said, why is law enforcement not caring and doing nothing? It fostered the initiation of appointment of counsel for the person who was charged. It set prompt trial dates. After Clarke, the vast majority of cases are not instituted by arrest. They're by citation, which means there are 21 or more days before the offender even has to contact the court. There's a delay in setting up a first appearance, or there was. I'll talk about that when I talk about our changes. And so cases were waiting 60 days before I even saw an offender before the court for a no contact order for victim services. And I think most importantly is law enforcement simply misrepresented what Clarke meant to victims. They said, we can't do anything, we can't arrest. That's 100% not true. Clarke says you can't arrest without a warrant. The court immediately put in place a telephonic warrant rule. So for the last 2 years, all law enforcement has had to do is pick up the phone, call me, and I could authorize an arrest warrant. It's a 15-minute process. They have not utilized that process, and it is sad for victims and survivors because the message it sent is that the system doesn't care, and offenders have been emboldened and victims have been discouraged from utilizing the system. And that's not debatable, at least in my area. I know it's working a little bit better in other parts of Idaho, but not ideally anywhere. And it's really unfortunate. And that is the impact of Clarke.
Mr. Lavey?
Yeah, so I will take some, I'm not sure how to respond because I kind of felt like law enforcement was just attacked on a general basis. And I'm glad the judge has clarified that that's what's happening in his area instead of casting that wide spell for all of law enforcement. I will tell you that in Meridian, we had a mandatory arrest policy in place. And so Clarke immediately took that tool away from us. We actually had to work with our prosecutors, and we worked with our prosecutors and our magistrate administrative judge quite well to implement a telephonic search warrant, to put that in place, because we all know that although the citizen's arrest is available to us, that our victims often don't want to take that route, which is why we had implemented a mandatory arrest in the first place. The one thing that's problematic for the telephonic search warrant and I'm talking statewide, is that trying to get self-service in some of the areas is not available, and that's not an excuse. It's just something we have to deal with. The other thing is, in order to get a telephonic search warrant, you need to have 5 people involved at a minimum. You need to have 2 officers at the scene to protect the scene. You need to have a 3rd officer that's getting the telephonic search warrant. You need to have a prosecutor in place, and you need to have a judge in place. And quite frankly, in a lot of our agencies in Idaho, they just don't have that resource. And so how can we make it work with that limited resources available to them? I think we took a step back. We went back into the 70s and 80s, like the judge is saying, is that ultimately the protection of our victim has to be the priority over enforcement. And Clarke definitely impacted that, where we weren't able to protect our victims. It also got to the point where the victim had to be the one that would leave the house instead of the suspect, because we couldn't order that. And that really goes back to what we got away from years and years and years ago. So it's definitely impacted us. We've put some tools in place in some places in the state, but frankly, there's a lot of places in the state that still don't have that telephonic search warrant available to them. And what they can and can't do is very limited.
So I know that there are obviously people are very passionate about this issue, and I would count myself in that realm as well. And so I think that now that we have kind of had a period of time to work through that initial shock and crisis situation about having how to address this, could each of you talk a little bit about the changes that you have made in terms of responding to the limitations of Clarke within each of your respective areas? Kim, do you want to go first again?
Find unmute. I think as advocates in dealing with our survivors, one of the biggest changes that we've had to make is in assisting them in collecting the evidence and documentation, and helping them get their specifics in order, whether it's for law enforcement or for a court hearing. And we had to, we didn't initially have to do all of that, but now we're seeing an influx of cases where we're having to really help with the documentation and the gathering evidence. And so a lot of that has been like the installation of Ring doorbells. We never had to do that before, really, but we don't have the resources to help the survivor get that Ring doorbell all the time. And then, you know, we've had to also train a lot more of our staff. We used to only have like 3 or 4 advocates that were specifically trained with safety planning and court advocacy. But now every single one of our advocates is trained with court advocacy and helping address the influx of calls we're receiving and the number of survivors we're assisting daily. Like it's grown exponentially.
And so, Kim, in response to that, have you had a similar influx of volunteers? Are you still working with still working with the same number of volunteers and the same number of staff?
Yeah, and especially I think COVID played an impact with that as well, because nobody could come in and help with anything. But I think maybe we'll see that increase a little bit, but for volunteers, a lot of them, they don't want to go through the training that we require to work with a survivor. We don't just let just anybody come in and work with a survivor. It's a 30-hour training, and then there's another 30 hours with an advocate that you're there. So 60 hours of training before we even allow them to be able to make a phone call or to sit down and talk with a survivor. So a lot of them don't want to do that as a volunteer. They'll want to bring in food, or they want to do something else like that, but they don't want to go through the requirements that we require as a program to be able to work with a survivor.
And then have you had to, or have you noticed any changes, or have you had to make any changes in terms of outreach to victims, or how victims are coming in contact with you?
Yeah, even with COVID, we had to really take a long, hard look at that, and we had to make some changes in the way we were getting all of our information out, whether it was through the website, Facebook, however that is. But then we're also now seeing that, and we knew this before really, but even now so more with the response to COVID and some of these other issues, for a survivor to leave their immediate situation and come to us, because we have a lot more rural communities that we work with out here in Canyon County. And so for them to be able to leave, come in and do what needs to be done and to take care of the situation, that's not always an availability that survivor might have. And so we are now having to increase our outreach, and that requires more staff, and that requires more resources to do that. And the funding always isn't there to help do that.
Thank you. Judge Peterson, can you speak to the various changes that the court has made in response to Clarke?
Sure, there's two key things that the court has done in response to Clarke, but first, I certainly don't intend to attack law enforcement. You're not going to find, I'm a prior prosecutor, you're going to find a bigger supporter of law enforcement than me. But I think we also have to talk honestly about where we're at 2 years out. And Jeff, please come help me up in Cooney County. I need help. I need help with the local culture and the local response. And I know one thing, law enforcement listens to law enforcement. And I could really use your help. So we've done two things. First, the court immediately enacted a telephonic warrant rule. Most judges felt that power existed for the judges already, but just to make sure it was clear, we enacted a simple telephonic rule. I assisted in drafting that. It's a very practical rule that is recorded through dispatch. It understands a lot of the problems of rural situations. You can use radio. There's a number of ways that is very effective. But we immediately enacted a telephonic arrest warrant rule. That was up and running within 30 days. And certainly your court and working with your ADJ down there was outstanding leadership. And then there was subsequently a change to the first appearance rule. Now, when a person is cited with domestic violence, they're given a document saying you are ordered to appear within 48 hours to the magistrate court for arraignment. So we sped up that time frame by court rule. So the court did those two things. But what we can't do, though, is affect directly the law enforcement decision in the field. And I have great trust in our officers. They know when there's a safety circumstance. And I want them to have the tools to be able to address that safety circumstance. Because in my view, they know. And so that is now in place. I personally am holding stakeholder meetings here regionally to get all the heads together to say, why are we not utilizing this process that exists more robustly? We have literally had in 2 years, two after-hour warrants. Now, I'm not here to say what the right number is. That's a law enforcement discretion issue, but 2 is the wrong number. So there are not only 2 DV victims that have needed the safety of the arrest of an offender warrantlessly. So we locally have to improve on what we're doing. And that's what the court is doing to try to respond to that with everyone's help.
Jeff, what about changes that you've seen in policing?
Well, I'll just also follow up on what the judge said. Is I actually sat in one of his stakeholder meetings, and it is kind of mind-boggling how a fairly large area up there, it's a pretty metro area compared to the rest of the state, how they have not embraced this and made more positive changes. I don't know what the answer is, and I think the judge probably is correct in that it's a cultural thing. I'll do whatever I can to assist. I know that Sheriff Norris is brand new up there. I've established a relationship with him. Maybe we can start there. I can tell you on a statewide basis, though, that there's a lot of agencies and a lot of counties that aren't as progressive. And that's the part that really concerns me in our rural communities about what's being forgotten. Couple things have come up in Ada County. When Clarke was first announced, we found ourselves involved with a number of suppression hearings because we had judges that were trying to interpret the Clarke decision as well as us, and we were having mixed signals from the judges as far as you can do this, you can't do that. And so we've had to overcome that here as well. And this isn't tied all directly to domestic violence cases. It's tied to any misdemeanor arrest that wasn't in view. And so what we've had to do is we've had to collaborate with our advocates and to find out exactly what's going on and what the victims are feeling. And really, we had to establish a think safety first, enforcement second. And we really have to figure out how to ensure that everybody's safe. That's the bottom line. And then we'll figure out how to hold the offender accountable. And then the other thing is we did implement the warrant process fairly rapidly. We had done it already for DUIs, and so we kind of used that template for domestic violence arrests. We hadn't done telephonic warrants in the past, and so we had to streamline that, figure out what's working, what's not working. We ran into some issues during the day, and when all the judges were busy hearing cases, when we were trying to get a warrant during the day, it was quite difficult, and it was much easier in the evening because they had someone on call. And so we had to streamline that process to find a dedicated judge that would be available during the daytime hours to also get a warrant. But that's key, because if you find out that the process is difficult or cumbersome, then law enforcement are going to get lazy and they're not going to utilize those resources. And so we need to make sure that we're doing everything that we can to make sure it's streamlined. And then the bottom line is we need to make sure that we are putting our victims first.
All right, so there have been, just to follow up on a couple of those comments, the notion of safety first and accountability second, which I think I saw lots of heads nodding when you brought that up, Jeff. In terms of rural agencies and culture, so in this leg where we may have some areas of the state that are not going to implement telephonic warrants for a variety of reasons, which could also not be culture, but could be staffing in nature. What do you see as the stopgap measure that policing professionals can use to kind of abide by that safety first, accountability second?
Well, the one thing that frustrates me is that what we have to do with the victims is we can't force the suspect to leave his house. And so it is always troublesome when we have the victim leave the house because that's his or her house and it gives the wrong signal. However, we need to make sure that we ensure that that person is safe. And if that's the route that we have to go, then we have to make sure that there's places out there that's available to them, shelters, resources for a hotel, anything. And I hate removing them from the house, and we can't force them to move from the house. But that's why we did mandatory arrests, is we knew that that separation was necessary. And unfortunately, with the way that the requirements are now, is law enforcement can't force either one of them to leave the residence. So we just need to make sure that there's a place that we can take our victims to that's safe.
Kim, I see you came off of me. Would you like to?
I did that on accident. I did that on accident. But I do agree. We only have so many rooms in our shelter, and we have transitional housing, but it's not a 24-hour transitional housing program. And I think that for the survivor to feel safe and then having them to remove them, so we're asking them to leave their home, their place of what is home, and then their children, and not just them, it's them and their children are removed from the home, and the offender is left at the house. Everything is just fine, and there's not been an arrest made. And then the survivor is left trying to figure out why the system isn't there for them. And we've struggled with that forever. You know, it's an overwhelming system. It's an extremely intimidating system. And they've already been through enough. And now we're asking them to collect the evidence. We're asking them to put everything in place to make the case statements. And then they get before the judge, and that's frightening to go before a judge. I've been before a judge, and it can be scary. It can be really scary. And mine was just to remove a tenant from a apartment. But that even in itself, I get in front of a judge, and he's like, Kim, it's just me. It's just Judge Owen. I'm like, I know, but I don't know what I'm doing here, you know? And so as a survivor to go through that's intimidating, and that's scary. And so now they don't have any services and any access and any protection, I think is what I'm trying to say. They just don't feel the protection that maybe was once there, but now it's gone. And so I don't think that that's necessarily fair to the victim to ask them to be making all the sacrifices when they've already been making all the sacrifices.
You're absolutely right. It's not fair on them. It's just yet another one of the many events within a domestic violence prosecution where the burden is shifted on them while the defendant has to do nothing. And again, if it takes time and energy to figure out where we can go with the victim, that really begs the question, why aren't we simply spending that time making the call for a telephonic warrant when there is a safety, when an officer in the field feels there's a safety issue? I don't understand why that doesn't happen. And if the answer is we're trying to make that call, Judge, but the prosecutors aren't responding or the judges aren't responding, well, then that's on us. And that's the next level of accountability piece that needs to happen. If my component isn't working right, then we got to own that. But it has to start with law enforcement feeling empowered to make that call telephonically. And I'm practical. I understand the issues of having an extra officer. Generally, a DV call has a cover officer. You generally have two officers no matter what. Make that call. Instead of calling a shelter for the victim, call the judge for a telephonic warrant. It really addresses so many of the needs, in my opinion. I understand that there are a lot of struggles. 30 years ago, 30 years? No, that's too long. 20 years ago, geez, gosh, forget how old I am. I was a prosecutor and I was presenting at the National Advocacy Center on rural issues on domestic violence. These issues have persisted. And I hear what you're saying about those things. So you have rural communities where proper priorities aren't being put here, unfortunately, and you have resource issues. But again, if we're going to take time to look for a place for that victim, let's use that same time ensuring safety by making a call and getting a warrant And if the system isn't responsive, if your prosecutors aren't responsive, or, yeah, it would be a different discussion, because then law enforcement's making the call and the system's not responding. Then we're accountable for that. And I would own that, because that's what we have to do.
Kim, just back to you for a minute in terms of as the system changes and tries to adapt, when you talk with other executive directors of programs around the state, the programs that are in more rural areas, which we have fewer, very few that are in what we would call rural areas. Most of them are in areas that have some pocket of population. Do you hear anything specific or a little more or different than what we would hear from agencies in the Valley or in Pocatello or Idaho Falls?
No, other than the fact that they don't even really necessarily have shelters in some of those more rural areas. And so just to get that victim to a safe place is even more of a burden on that program. I mean, like, there's our shelter here, there's a shelter in Boise, there's shelters in Pocatello, but in some of the more rural areas, there isn't that accessibility to immediate shelter. And so that causes great concern and puts more burden on that program then to provide that resource to be able to get that survivor into a hotel or into a place of safety.
And Judge Clarke, for people who don't know, how are judges dispersed around the state? So if we're talking about a rural place, not a pocket of population, but more of a rural place, are we seeing judges they would be in the county seat of a rural county, or how are they available to policing professionals?
Yeah, that's a good question. Every county has at least one magistrate judge, and that's one of the reasons. So that the county has someone that's available. Generally, the duties of a rural judge are sort of twofold. On the one hand, they're much lighter because they generally have far fewer cases. I mean, my caseload is triple what most judges have. But they also are the only one that gets those after hours calls, whereas I get them when I'm rotating, I'm the on-call judge. So nightly, they're always on call, but their daily workload is perhaps not as great. But every county has a magistrate judge who can hear an emergency request for a warrant. There might be some delay during the day, as Mr. Lavey said. That's very true. And we've had to address that here internally. But there's always a backup process. And if someone needs backup, if another county needs backup, our on-call judge often does backup for Shoshone and Benoit and the other counties where there are fewer or only one judge. So we have a process in place of backup that should help with those issues. But that's how they're distributed around the state. Obviously, larger jurisdictions have more judges, but every county has at least one.
And I have a follow-up to that, Judge Clarke. And also for people who don't have may not have a lot of information or knowledge or don't have a lot of contact with the judiciary. Can you just talk a little bit about if the Supreme Court issues guidelines or issues new rules, do judges have discretion to follow those rules, or are they bound to those rules? If we're talking about culture in a location, if you have a judge that doesn't necessarily agree with that guideline or that suggestion or rule, do they have discretion to deviate or not follow that?
Not really. It's hierarchical. When the Supreme Court doesn't issue guidelines or suggestions. It only makes decisions or signs off on rules that we have enacted. Both of those are binding on all the members of the system. So my opinion of Clarke doesn't matter. That's the decision of the Supreme Court. I'm a lower court judge. I'm bound to follow it. It's not my role to say those things. I have to take that decision like everyone else and live with it. I should point out, though, that's nothing new. Even though we're talking about this in the domestic violence context, And it is a huge impact in domestic violence, no doubt, disproportionately so. You know, decisions by judges, whether federal judges or state Supreme Court judges, have dramatically changed and required responses by the system, you know, throughout the entirety of our course of our legal history. And, you know, you can cite a dozen of them off the top of your head that made people scramble and respond and how they're going to address it. But no, judges are not free to disregard it or disagree with it. And candidly, neither are the law enforcement agencies, though these days it seems like there's a additional pandemic going around, this idea of, well, I don't have to follow the law if I don't want to. That isn't how it works. So no, we're not free to do that, and neither is anyone else.
Jeff, could you talk a little bit about, especially in your role as executive director for the Idaho Sheriff's Association, but also in your 35-year career, when we're talking about rural counties like Benoit or some of the other really rural counties, what are we talking about in terms of the number of officers who would be on the road in any given shift?
Well, unfortunately, that number could be 0, and you'd be lucky if it's 1. And a lot of times there's not 24-hour coverage in a lot of our rural areas. They're home in bed asleep, and they get called out just like anybody else. I actually worked in a rural county where there was no coverage from 4 to 6 in the morning, and that still happens. But other times there's 1. And that person has to handle all calls. And you see some of the wide areas of these counties where there may be only a few hundred or a few thousand people, but the square mileage is unbelievable. I've actually had to run code to a gas pump just to put gas in my car to continue running lights and siren to a call because I was 110 miles away. And we already know that the situation is going to be over with by the time we get there, and we just have to deal with it. Some of the more populated areas have done a good job as far as instituting the telephonic search warrant process, but I'm not sure that all 44 counties have. And so the question is, if they don't have that implemented, then what options do they have? And what do we have to do? And I guess I'd go back to what I said before, is I absolutely hate the fact that we have to put those burdens on the victim, because that is what we got away from with the mandatory arrest. But we need to make sure they're safe too. And so as much as it sucks that we're suggesting that they leave their home, their life is more important to us, or at least to me. And I'm not sure where we're going to go with this, how we're going to have to overcome this, because it's not going to change. And so I'm with the judge in that we have to change culture, and it's going to have to take all of us to do that and make sure that our victims are safe out there.
On that topic of needing to take all of us to change that culture and to adopt that safety first, accountability second motto, could each of you speak to whether there are coordinated community response task forces that are working in your areas or in areas near you? That was certainly a push in the 90s into the early 2000s. My perspective has been that they've kind of fallen off, but I may not have a good touchstone. So if you could each kind of comment on what you know about existing formalized coordinated community responses, I'd appreciate that.
I guess I can go first. Is that I think we have gotten away from it to a large degree, because we really had kind of changed behavior and changed approaches, and at least I'm only speaking for Ada County, where we actually implemented mandatory arrests when we were not required to. We did it anyways because we had the tools and we could make it necessary. We could diffuse the situation we could get that person into the process, into the system, to start holding them accountable. We've had great success with our DV courts here in Ada County as well. But the minute the Clarke decision came out, it's almost like it threw us back 20 years. And unfortunately, in Idaho, is that we seem to be 20 years behind the times already on a lot of resources out there for victims, that we just took major steps backwards. And so we have to look at the parameters that we have, and then we have to get together as groups to decide what can we do to make sure that we're moving forward in assisting our victims. And I don't have all those answers yet. I do know that, and we'll probably talk about the constitutional amendment. I have some comments on that as well, but we have to think beyond that. What can we do to make sure that the system is working? And I think it really is going to come down to the telephonic warrants and on-call prosecutors, on-call judges, and just deal with it.
Yeah, I agree that the coordinated community response seems to have slipped a little bit. That's a core tenet of domestic violence responsiveness. It's one of the foundational concepts of the coordinated domestic violence courts countrywide. Ada County is a mentor court. The court that I preside over is also a mentor court. In other words, we train other courts how to do this. And one of the reasons I'm holding stakeholder meetings to try to navigate our way through this response that we're having in my area is because there's not a coordinated community response. And in that absence, I had to be it by calling those meetings, which several of the people who are on the panel here today are a part of. And so we need to strengthen that model, Doctor, I would say, is a strong suggestion that I would make. Strengthen a coordinated community response. It shouldn't take the judge to get everybody in the same room to say, hey, why isn't this working right? That should come from the coordinated community response staffing, for sure. So in other parts of the state, that might be working better. That's my hope.
Here in Canyon County, we do have a DV task force that meets on a regular basis, and our staff does attend the DV task force meetings. But I think a lot of times their hands are tied as well with how to make changes to the system. And again, and I don't mean for this to be awful towards the system, but when I first became executive director, we had a DV court in Canyon County, and we were seeing great results with how the victims were being served, how the offenders were being held accountable. Judge Lee was doing an amazing job with that system. And then, and I can't even remember what really happened, but DV task force became, or not task force, but DV court became no more because the offenders had figured out how to wiggle their way around that so that they didn't have to go in front of Judge Lee. And so, once they figured out that system, and they all talk, they all know, and so they all figured that out. And so then DV court kind of went away. But I think that there's still conversation about getting that back, which would help so much with making sure that the responses for these survivors is where it needs to be. But right now, in all honesty, it's all about the offender, and they have all the rights, and those survivors really don't have any rights, really. That's how they feel.
Jeff made a passing reference to the constitutional amendment, or to a proposed constitutional amendment. And so we might as well have our comments about that idea. So for those who are new to the topic, in order to address the loss of warrantless arrest, since it was ruled unconstitutional, it would take an amendment to our state constitution in order to allow those warrantless arrests for misdemeanors in general, or more specific specific types of misdemeanors. There was, and Jeff can correct me, but there was the session, the 2020 session, saw a proposal, I think a bill was printed. There were hearings, but it did not, and it had a majority of votes in the legislature, but not enough because it requires 2/3. And then this last session, I believe Representative Cheney's bill was printed, but it didn't have a hearing. So if people could offer any comments or perspectives they have on a constitutional amendment or the likelihood of a constitutional amendment, I would like to hear those.
Lisa, I can talk on that a little bit. You're correct in what you said. In 2020, there was a proposal to have a constitutional amendment that would give restore the powers back to law enforcement that we lost with the Clarke decision. One of the things that I had said was that trying to restore that with everything that law enforcement lost was not the way to go. And I'll get to that in just a minute. And that we really had to focus in on giving that authority of a misdemeanor arrest not viewed for personal safety type calls, domestic violence, restraining orders, civil protection orders. There's some impact on some of the DUIs, not witnessed type laws. And nobody really understood what we were trying to accomplish. And a constitutional amendment is a very, very big ask. And so we just didn't get to 2/3 vote. The problem that we have is even if we do get to 2/3 vote is having the citizens understand what is being asked so they can vote appropriately. The last thing that people want to do is give law enforcement greater authority to arrest people. And that is even more so in 2021. And so at the very beginning of the session, that unbelievable session, they had limited what they were going to hear. At least that's what they told us. And so the Prosecutors Association had decided that they weren't going to push for the constitutional amendment based upon the legislators saying, hey, we're going to have a limited scope this year. I, on the other hand, was saying that we should push it anyways because we need to do it. It's the right thing to do, but we need to focus it in on safety of citizen type calls, not giving us authority for everything back. The other thing is unfortunately, politics play into it in that who sponsors the bill or who's named on the bill is also key. And so we did go to Chairman Cheney and tried to get his help, and we did get it. His intent was to give it a informational hearing so we could educate everybody, so then we could go back and get the bill printed and heard the following session. But frankly, it just turned really goofy and that just never happened. I think the constitutional amendment's a very, very big ask, and the legislative session is only a small part of getting that changed. So it's going to have to be something that's driven by someone other than law enforcement, in my opinion, because the citizens, the last thing they want to do is give law enforcement greater authority to arrest people. So it's going to have to come back from other people to say, this is why it's important. This is the impact it's currently having on our victims in a negative way. And we need to ensure that the tools are there to make sure that they're safe. I'll leave it at that.
All right. Kim or Judge Peterson, any comments?
I
I
think
think as a nonprofit, our services are limited anyways due to funding. And if I'm not the one out there making sure that the funding is here to support the services, to get the staff hired, to get everything in place that we need, we work with the survivor from initial contact point to way past. I mean, we've had individuals that we served 14 years ago come back and call us and say, hey, I need help with this now. And we're able to help them, whether it has nothing to do with DV, and sometimes it may. I mean, you see them once, sometimes you see them 15 times, but the funding and the limited resources that are there to help make sure and ensure that these survivors get the services that they need and the protection that they need, it's critical. And so I don't know where that funding is going to come from. I know that there's been more cuts in the funding that we're going to be able to receive, even down from the federal funders that we have. And I just see funding as being a critical component to all of this, whether it's with the court system, whether it's through the law enforcement, whether it's through our community programs that again are here. We're not here just for that system-based piece of it. We're here for years on. And so how do we make sure that we are here serving the needs?
Judge Peterson?
Yeah, I think Chief Lavey summarized it really well, the current process that's pending. Because the defect allegedly is constitutional, the fix has to be constitutional. And it is difficult to ask or get constitutional modifications. Though, again, I think, as you say, that's an education piece. But I think we're also dealing with a cultural piece. I think Chief Lavey said that, well, we do seem to be a little bit behind. What we can't avoid talking about when we talk about domestic violence, though, and crimes against women and children generally, I was a sex crimes prosecutor in Las Vegas, is the underlying gender bias that exists, the devaluing of the reports and violence against women. And I talked about this at a gender in the law class recently when I was a guest speaker. I said, you know, you hear the phrase, it's a he said, she said case. Well, have you ever heard a case as a he said case? Literally every case is two people with different views of what happened. We're capable of sorting that out. What's so special about a he said, she said case? Well, there should be nothing, but it shows the underlying gender bias regarding dangers to, safety for, and accepting the truthful reports of female victims primarily. It's gross and it needs to stop. And we need to have a more intelligent and meaningful and informed discussion about these things so that we can see the need for addressing the arrest authority that law enforcement needs to have to address the safety concern. Because, you know, back in the day when the framers of the Constitution, and let's not get too caught up on what the framers thought, let's not forget, they continued and indoctrinated within their documents slavery. So we're not talking about people who are so enlightened that their judgment can't ever be questioned. You know, the rights of women weren't even established at that time. Women couldn't vote at that time. You know, it's a little ridiculous to have this historical view all the time. The common law progresses forward, and we did through Ada County and others' influences, arrest authority, a statutory change. Those were wise responses to the growing understanding and needs of our communities. And we did take a step back. Sometimes the law works that way, and I understand that. But what we have to do is respond. But as we respond, not only do we have to realize we're making a difficult constitutional ask to go that route, we also need to have discussions regarding why is this so problematic to talk about? And you can't get past that without addressing the gender bias issues that underlie it. And when we talk about sort of cultural or rural norms, I'm not going to say we should pin that just on rural locations, because that's not true. That's pervasive, unfortunately. And when victims are viewed as just sort of complainers who are just gonna change their story or make false allegations, and statistically, there's literally zero evidence that there are more false allegations made in domestic violence than any other type of offense. But yet we have these silly notions of, well, it's a he said, she said case. Well, guess what? You sort that out every day as a judge. That shouldn't be a problem. And if any judge has a problem with that, that's a problem. I mean, I call it, I talk to my other judges about this. Every day a parent comes in and tells you they're a good parent when they're not. A drug user says they're clean when they're using. Like literally we sort those things out every single day. And so this shouldn't be the problem that it is, but we need to have an intertwined discussion about gender biases as we move forward on addressing this issue, because we simply have to value domestic violence victims. And that's part of the problem. I'll give you a scary example. It's not a perfect apples to apples example, but it's close. A couple of years before Clarke, a federal decision came down that said you can't now draw blood from a DUI offender without a warrant. Well, that's really no different than Clarke. You can't arrest the guy without a warrant. Guess what? Within 3 months, we had a system set up to do after hours blood draw warrants. Why in the world is it taking us 2 years to get warrants for our domestic violence victims? How in the world can blood draw warrants get a more timely response than our spouses and our intimate partners? Everyone should be troubled by that and should ask the persons that are involved in the system, myself included, to do better, because we have not done better for our domestic violence victims. In parts of the states have done better than in other parts of the states. Unfortunately, my part is lagging behind. I'm trying to correct that, but it's an intertwined and complex problem. It's not just a resource problem. It's a willingness problem. It's a leadership problem. It's a gender bias problem. It's you know, if we fall under that grand umbrella of cultural, but it's going to take push in all those areas and honest accountability in all those areas for us to improve. My hope is if there is a constitutional amendment, we'd be able to go back to the general pattern of arrest, which is frankly where probably most things should be at. The officers in the field can assess safety issues very well. I have 100% confidence in that. But it's a problem. And the constitutional ask that Jeff, I don't even know what title to give you. I've used different things throughout the time. I know you're a former chief. Is that like president? Does that stick forever?
You know, unfortunately it does. Even the sheriffs have called me chief. So I answer to hey, you. And I actually had one of my former officers call me Jeff the other day and about fell over because I wanted that a long time ago. So I answer to anything. But
well, Chief Lavey, I think, is really correct when he says that it's a difficult ask to ask for a constitutional amendment in any state at any level and for anything. But hopefully education will move us forward. Thank you.
So in Louisville, well, first, thank you all for those comments on the constitutional amendment. I know this next question isn't a popular question. I know it's not going to be a popular question with the chief. He doesn't like it when I ask this question. But sometimes when we are forced to make big changes or unexpected changes, and especially when they're difficult changes and we're not really happy about those changes, sometimes unexpectedly positive things happen. And so I just wanted to ask if there has been, in the wake of Clarke and changing how each aspect of your system has moved to address Clarke, if you found any unexpected positive developments, things that you didn't think you could do, but now you realize you can do, or new sources of support or new ideas of ways to overcome barriers that you thought were just either they were new barriers or they were barriers that just couldn't overcome?
Lisa, since you think I'm afraid to answer that, I'll answer that. And I really want to go back to something that the judge just said too, in regards to the telephonic warrants. And what's troubling is if a county has that process in place and it's still not being utilized, that's more troubling to me than if they simply don't have that resource. And so when I came to Idaho, let me back up. So in my career, I came from Washington State. In Washington State, we had telephonic search warrants. I could actually pull over to the side of the road. I could get a judge on the phone, and we could get a telephonic search warrant immediately. You know, within 20 minutes of waking him or her up in the middle of the night and listening to what I had to say, answering a few questions, we were good to go. When I came to Idaho, that process was not so simple. And I don't know if that was that way across the entire state or if that's just the way it was in Ada County, but we had to involve the prosecutor. And then that is just another barrier that's put in place, or I should say an obstacle that's put in place that we need to overcome. And then trying to convince the prosecutors that we need a warrant. And then they're not quite as quickly as we need them to be or what we want them to be. And so it's just the obstacle we had to overcome. And the judge is absolutely correct in that when DUIs came about and that federal decision was made, we implemented a telephonic search warrant rather quickly, and surprisingly, it worked, and it worked quite well. So I think that's what helped us here in Ada County, in that when it came time to implement a telephonic search warrant for domestic violence, we already knew it could be done. And so we started implementing that same process, and then we just had to work on the efficiencies of it. You know, we couldn't use a template like we use for domestic or for DUIs. We had to overcome the availability of prosecutors and judges and some of those things. But we worked through that. Unfortunately, that's not happening in our entire state. And we need to ask why. And I saw one of the questions that we're probably going to get into is, why hasn't the Supreme Court put rules in place to say this is the way it's going to be in the statewide? And I don't know what the answer to that is, but when you got individual counties doing their own thing, some are got a lot more forward movement than others. And I don't know what it's going to take to wake people up and make that change.
Thanks, Jeff. The question was actually, why is the Supreme Court not utilizing trial court administrators to implement the process statewide that Judge Peterson was speaking to?
The judge can answer that when the time's appropriate.
That's just kind of not the role of the trial court administrator. It's a good idea. I mean, I hear what you're saying, but what the Supreme Court did is the Supreme Court enacted, there's a criminal rules committee. I'm on that committee. We wrote the telephonic warrant rule. And one of my inputs on that rule was to take the prosecutors out of the rule. I said, let law enforcement contact the judge directly because it's a probable cause process. That's no different than law enforcement submitting probable cause for arrest to me over the weekend. They can submit probable cause for a warrant as well. It's an arrest warrant. It's not a search warrant. That's different. So the rule was written with that involved. Then how it's utilized throughout the state is left to the discretion of the agencies. Again, it's not up to the court to use a telephonic warrant rule. It's up to law enforcement to use it. I can't command them to use it. Neither can the Supreme Court. It's up to them to use it. And that's kind of the accountability piece we're talking about. Right now, in my area, it is dramatically underutilized. Like, I don't think I would involve myself in what number is the right number. That's entirely a law enforcement discretion issue. And again, I trust the officers who are in the field to know when that is, but it's not 2. I mean, and that was only until a couple months ago. It was 0 for like 14 months. So 0 for sure is the wrong number. Again, what the right number is, that's for law enforcement to determine in their discretion, but the role isn't for the court to mandate agencies to use a rule. We can't do that. The agencies have their discretion on how to do that. And hopefully by training and leadership, that discretion is utilized in a way that the community thinks is appropriate. So I hope that's kind of a roundabout bad answer. I'm sorry about that. But I saw another question about fingerprinting. That's also a huge concern.
Yeah, and we only have 10 minutes left, so I would like to have an opportunity for us to address those questions. Tamara, do you want me to read them or do you want to throw them out there?
You can go ahead and read them.
Okay. And so, yes, Judge Peterson, we have a question out here about the fact that Clarke has also had significant implications to the back end of the system. If perpetrators are not fingerprinted during booking, the DV cases are likely to never be entered in NCIC or other federal databases. Are the right people talking about these gap areas? Could fingerprinting be implemented as a term of sentencing in DV cases, much like DNA testing at the district court level?
The short answer is yes. And I'm trying to implement a more consistent way of making sure I always order my out of custody DV defendants to go and fingerprint. I order it as part of the no contact order process as well, because if there's not fingerprinting, then things aren't entered into the NCIC database, which is the national criminal database that helps our law enforcement know if there are valid no contact orders or other similar orders. And that's true about the back end. Yes, those things can be done, but you need an educated judiciary to know to do them. I'm trying to spread that word and also develop a more uniform approach on how it's done. The problem is we have a handful of judges that really know what they're doing with domestic violence, and then a lot of others who need additional education on that, because when we specialize courts, that has an unfortunate side effect of not training everyone. It congeals the expertise in a couple of people. And that is a side effect of specialization that's unfortunate. We need to continue to get that education piece out. But it's not just the back end, it's also the front end. Locally, and I don't know what the statewide numbers are, but our domestic violence citations, even without arrests, were down almost 50%. We did not magically solve domestic violence after the Clarke decision. What that means is the number of people cited and offenders being held accountable has dropped drastically. Those numbers get a little wiggly and hard to chase, but they're lower than they have been. I can't give you an exact number. I don't know what the statewide numbers are. And unfortunately, I heard a couple of politicians talk about crime being down. No, if domestic violence cases are being undercited, crime is not down. That's not what that means. So there's front end and back end components to Clarke as well that really deserve a statewide look. And it would be nice to have a statewide task force look at this. I think that is and Dr. Bostaph's article and findings and that study was phenomenal. In fact, reading that was one of the reasons that got me to hold stakeholder meetings and say, hey, how are we going to fix this? So that was very influential and really, really, really useful.
Thank you. Let's see, we have another question here about, in terms of, in lieu of a constitutional amendment, has there been any discussion about adopting maybe multi-level felonies? So some states have, maybe a domestic violence in the first degree, a domestic violence in the second degree, that would maybe take some of those cases that are now generally seen as a misdemeanor, even though they have evidence of physical violence, and move them to a felony level, which then opens up the felony arrest process. Has anybody here heard any discussions about restructuring statute?
Hey, Lisa, I'll answer part of that. I've heard of some unofficial, and what I mean by that is law enforcement had decided that they were going to arrest for felony only and not misdemeanors anymore. But that really goes against the system as well. And is that the right thing to do? There's been no discussion officially on tiering felony level cases with the legislature. And I think that politics would play into that as well in regards to that in our state, where they're not going to want to make all domestics a felony. And I know a lot of people aren't going to like this, but I'm going to say it because we are in the state of Idaho, because it has to do with possession of firearms. And you're going to have a fight with those that are currently elected in office to try to overcome that.
Yeah. So if you're convicted of a misdemeanor domestic violence or a crime of violence reduced from domestic violence, still under federal law, you're prohibited from possessing firearms. So even misdemeanors carry a firearm restriction unless the case is reduced to a non-violent crime, which does happen sometimes. There is already a felony domestic violence, for those of you who don't know. That's domestic violence that has a substantial bodily harm component. There was some discussion initially after Clarke, maybe law enforcement would be more liberal in finding that, but that's a bad solution. You don't want law enforcement stretching on crimes just to be able to arrest. And though that might have happened a couple of times within the first 30 days, that pretty quickly disappeared as a possible approach here. So the idea of tiering, I don't know how else it would be tiered. The problem is our society says that, animal cruelty may be a felony, but cruelty against your spouse is only a misdemeanor. And, we're going to have to come face to face with that. Why is that? Again, I think it comes from gender bias, believing that female victims somehow falsely report this all the time. There's this epidemic of false female reporters out there. There's no evidence to support that, but it's just flat sexism, candidly. And the chief is right that people are not going to like the idea of more felonies because it impacts firearms. And until just a couple of years ago, I think we could have had a logical and reasonable discussion about this. Today, that just seems off the table. And I don't know why, but it's sad.
Judge, a question just came into, can you clarify traumatic injury for the group so they understand what that is?
Yeah, and you know what, I'm glad you said that, because the term is traumatic injury, not substantial bodily harm. That's the aggravated assault definition. Sorry about that. Traumatic injury by case law is determined to be, and there's a definition of it, but it's impairment of functioning, a significant visible injury or impairment. There are some cases that really stretch what that means to include bruising and things like that, but I don't think that's anything that people are very comfortable going on. It usually takes a more significant injury to be considered a traumatic injury. Loss of a use of an arm, broken bone, things along very large cuts and abrasions. Whereas most domestic violence, the batterers are smarter than that. They just don't often inflict those kinds of injuries. And, I don't think we should reward that kind of decision-making, but, like
and we shouldn't let it get to that point either, because at that point, then that's when the homicides are going to happen. And we're going to see more homicides come from this, because they know that they have just that much more leeway to do whatever they want to do. And I think from the victim's standpoint, they don't report because there's no reason to report, because when they do report, there's no response to it, because maybe law enforcement's hands are tied. I don't know, but we hear it all the time. They won't do anything for us. But I'm not going to pick up the phone and call. It doesn't matter if we don't get anything we want anyways. And even if we do go before the judge, we still get slapped down to a little bitty misdemeanor, and the offender gets his little hand slapped. And then here's the survivor trying to figure out how to put all the pieces back together and get her children to safety and get a job and figure life out from that point on, and still worried about the offender being somewhere out there, even with a protection order. That's a piece of paper. We've seen plenty of survivors who have come in contact again with their offender because the no contact order was, I mean, just go look on the registries right now. You can see a lot of NCO violations and protection order violations. I mean, they're out there. And so it still continues. And so I think from the victim standpoint, I think that if they had better response services and could feel more trusting of the system, but we're, as advocates, we're asking them to believe in a system that really isn't there to help support them. And so for us to help them navigate through that and help them understand that it's the law. It's not necessarily the officer or the judge, but it's the laws. And so it's going to take a lot of conversation, but we've got to get past conversation into, all right, let's make some decisions, just like with our sexual assault coordination.
Yep. But Kim, here's the problem. They deserve to be told the truth, and they're not being told the truth right now. When they're being told there's nothing we can do by law enforcement, that is a lie. Law enforcement can get a warrant, period. So when they say to a victim, our hands are tied, we didn't see it, we can't arrest him. No, you can't warrantless arrest him. Victims deserve to be told the truth. Unfortunately, the truth in some areas, including mine, is we have the ability to get a warrant for you and arrest him. We're just choosing not to do that. And that's an accountability piece, right? So I don't want the takeaway to be the laws or the system are making this bad. They're not. The laws have added a wrinkle that we quickly made a way to overcome. Those solutions are not being utilized. They're not being utilized properly. And that is the truth of the impact of Clarke. It's not that law enforcement lost the ability. It's that it just got a little bit more annoying. But domestic violence victims are worth it, and that should be done. And 2 years out, I think the resource argument just starts to fade. Like, I get it, I understand it, but we've had 2 years to figure it out. I get it, that's, you know, and tell me what I got to do to help you make this happen, because I want to see this happen properly for our victims. And I think the chief has that same attitude. Victims first, safety first. We got to get the people who are like-minded like that to influence the decision makers and educate the decision makers on what tools they have, and not lie to victims that, oh, well, the law says we can't do it anymore, because that's not true. That's just 100% not true. And no one should tolerate victims being lied to. The system may not be great for them, but they should not be lied to and told that we're powerless, because you know, that emboldens offenders. The offenders are getting the message about this big time. The guys in my domestic violence court, they know. But I say, oh yeah, I educate them about all they got to do is call me, and they have my cell phone number. So, you know, I don't want anyone to tolerate the idea that it is the law that is stopping this. That's 100% not true.
So now in hindsight, if I knew we were going to get such great questions, I wish we would have ended the panel discussion a little bit earlier so we could have gotten to all the questions. But we are late here by a couple of minutes. So I end every one of my days reading a quote about hope, because that's what I want to think about before I go to sleep at night. So I'm going to ask each of our panelists to tell us one hope about that you have about moving forward after Clarke. Kimberly, I'll put you first. I know you can get me later.
I think the biggest hope that I have out of all of this is going back to what the judge said, and that's finding the solution and making sure that the system really does know that there are these services available and that they can do what they need to do, and that we can really be there for the survivor.
Chief?
I would hope that we could change the culture and we could help educate people to understand what impact their decisions or lack of decisions are having on our victims. And I support with what the judge said quite well, is that there is a disconnect amongst our state. And I would almost think that we need to have a state group put together to try to implement change. And I'm there to help in any way I can. I think he's there to help any way he can. But that's just two of 1.8 million people in this state. And so we need to find more like-minded people to figure out how we're going to protect our victims, because in the long run, I don't think the constitutional amendment is ever going to come our way. If it is, great, but we're still going to have other problems that we're going to need to overcome. Because even when Clarke didn't exist, you didn't have law enforcement making arrests when they should have. And so we need to get like-minded people together to figure out how we're going to impact our state in the future.
My hope is we're further along today than we were, last week. This conference in and of itself is a thing. I hadn't had a chance to speak to the chief like here today. And I have a funny feeling, though my intro remarks might not have felt great. I think at the end of our discussion here, what you see is you start connecting people who have a chance to get together and try to influence and create change. And you just gotta keep grinding. And it's hard. I get resistance from my colleagues. I get resistance from lots of places. And believe me, it would be much easier to not have this. I could not be a domestic violence court judge, get paid exactly the same, have less work to do, but this is the good work of the court. This is a good work that we're called to do as people. And you wind up meeting good people who say, yeah, we got to make a difference. And they get together and things change. Is it changing as quickly as I think it should? No, but I'm not giving up. I don't think Kim's given up. I don't think the chief has given up. I know Dr. Bostaph's not giving up. And, all of you aren't giving up. So once we start unifying our voices, it becomes difficult to ignore the conversation that has to happen. And the bottom line is it's for safety for our domestic violence victims. And that's a message everyone can get behind, I would hope. So, but hope is my word and my thing that I would say I find as I do this work. It's also shined light on some interesting things that I wouldn't have discovered. It helped me learn weaknesses in our system for our community-based advocates. I didn't realize some of the flaws, and this Clarke process has shined a light on that. And I was like, wow, I didn't realize that wasn't working right. So, sometimes when you shine the light, you learn things you didn't know. So it's been helpful in that way too. Sorry to talk so much.
I thank all the panelists for agreeing to do this today. I really appreciate it. It's nice to see your faces. Thank you for everybody who attended this session. I hope the rest of your conference is great, and we're going to sign off. Bye.